The first case to come before the court this morning is State of Ohio versus Devin Depetro. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the repellent and wish to reserve any time for rebuttal, please let me know when you get started. I'm keeping the clock this morning. Please do not use the name of any victims or minors, as we are video recording this and it will be placed on the court's YouTube channel. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. I would ask this court to reserve just about 3 minutes for rebuttal. In this case, there's two primary issues in this case. The first issue is that my client entered a plea to an F2 prior to his sentencing. He filed a written motion to withdraw his plea. Now, in the written motion, trial counsel indicated that my client would be asserting that he was not guilty, that he was innocent, and that he would present facts to that case, to that effect. When the hearing was held on the motion to withdraw, which was in the same time period as basically the sentencing was held after, there was not one piece of evidence presented on defendant's behalf at that hearing. Not one piece. The only thing that was indicated on the record was that my client was basically asserting that he was not guilty and that he was scared when and under pressure when he entered his pleas. Not one evidence. He did not take the stand. There was absolutely no evidence. And I think that this goes to the question of ineffective assistance of counsel. The basic requirement for motions to withdraw is that the burden is on, obviously, the defendant in this case to present evidence to establish that the motion withdrawal should be granted. And these courts' rulings that deal with motion withdrawal always start with, well, somebody had competent counsel. Somebody had counsel who was prepared. Someone who had stuff of that nature. That's the problem with this case. There was, quote, competent counsel, but competent counsel entered incompetently. And that is a disservice and why the motion withdrawal should be granted. Now, one piece of evidence was presented when there was a motion filed by the defense that claims of innocence would be made. And that is the basic for why these courts, in this situation, your courts, are making rulings about motion withdrawal. And that did not happen, didn't even come close to happening. There's got to be a floor. When something has to be, when you're doing these cases, I think you should be looking at the law and knowing what needs to be done at a minimal. And I don't even think a minimal is done here. And so I would ask this court to respectfully overturn the denial of the motion withdrawal on the basis that my client received ineffective assistance of counsel and send it back to the trial court for a hearing. The other issue is that in this situation, my client got 6 years and he's never, ever, ever had any criminal conviction of any situation at all. And he got 6 years. He didn't have any tickets. He didn't have a criminal offense. He didn't have anything. He didn't go to trial in this case. Maybe he should have, and maybe he will. But 6 years for an offense where he had absolutely no prior conviction. The facts of this case are problematic. I know that, but it's individualized to this particular defendant. And so when you look at this particular defendant, what is his criminal history? What is his, involvement in this case to some degree? What does he say his involvement in this case to some degree? I believe that 6 years that he got was unlawful and an abuse. Your Honor, I do believe that this case should be returned for the trial court for a hearing on the motion withdrawal. Thank you.
Thank you, counsel. You'll have a full 5 minutes for rebuttal should you wish to utilize it.
Thank you.
Counsel for the state?
Thank you, Your Honor. Good morning, Your Honors, and may it please the court, I'm Vince Felucci with the Medina County Prosecutor's Office on behalf of the appellee, the state of Ohio. The first assignment of error is that the trial court abused its discretion when it denied Depetro's pre-sentence motion to withdraw his guilty plea. The fourth assignment of error is kind of goes along with that because it states that the trial court committed plain error by not informing Depetro during his plea colloquy that there was a presumption of prison for a felony of the second degree that can be rebutted. Well, actually, the court did say there was a presumption of prison for a second degree felony. It just didn't say the can be rebutted part, which I'll get to. It does not have to do. In fact, it went above and beyond, even saying that there was a presumption of prison for a second degree felony. It did not need to. The court did not even need to say that. The trial court correctly ruled that Depetro did not meet his burden for demonstrating a reasonable and legitimate basis for withdrawing his plea. Depetro wanted to withdraw his guilty plea simply because he changed his mind. Case law in this court is abundantly clear throughout the years. I've cited many cases in my brief that a change of heart is insufficient to allow a change of heart, change of mind, whatever you want to call it, is insufficient to allow a defendant to withdraw his plea, even pre-sentence. At the plea colloquy, the trial court correctly explained all of the potential maximum penalties. There's no dispute there. He stated he was satisfied with his counsel's representation, had enough time to speak with his counsel about the plea. Depetro's only argument in support of this motion to withdraw was that he was, quote, scared and, quote, under pressure at the time of the plea. Depetro did not and still has not elaborated as to why specifically he felt scared or under pressure at the time of the plea. Some level of nervousness, we know, is of course normal for any defendant who is in front of a judge pleading guilty to felony charges. Depetro's bare assertion is nowhere near enough to justify a trial court allowing Depetro to withdraw his plea. As I said before, Criminal Rule 11C2A requires the trial court to inform a defendant of the potential maximum penalty and to inform a defendant that they are not eligible for probation if that is the case. Now, that is not the case in this case. He was eligible potentially for probation, so that didn't apply here, that part of C2A. The trial court, again, correctly informed Depetro of the potential maximum penalty, went above and beyond what it was required to do when it informed him that prison was actually presumed for a second-degree felony endangering children. The trial court was not required to state that the presumption can be rebutted. Depetro cites no authority stating that's the law because it's not the law. And by the way, it goes without saying that all presumptions can be rebutted, or else they wouldn't be presumptions. They would be mortal locks. Depetro's counsel did the best he could with what he had, which was nothing outside of Depetro's generic claim of innocence and Depetro's claim that he was, quote, scared and under pressure at the time of the plea. He simply changed his mind. He still doesn't say what evidence or witnesses his counsel could have or should have put on at the hearing. That's because there were no witnesses and there was no evidence to present, Your Honors. Depetro noticeably doesn't suggest that he take the witness stand himself, at least as a brief, where the prosecutor, of course, would have had a chance to cross-examine him, and he would have he could have potentially incriminated himself before the trial. I think that's a reasonable and actually sound trial strategy to not have Depetro himself take the stand, where he likely would have just said the exact things that his counsel had already said on his behalf. In terms of the sentence, Depetro argues that the 6 years was excessive. Of course, we know that's within the statutory range for a felony of the second degree, and not even the maximum for a second degree felony, which would have been 8 to 12 years. The trial court laid out the gruesome facts of this case in great detail on the record, which I encourage this court to read, and I also quoted in my brief. I won't go through it all here, but it's the conditions that this 5-year-old was found in, and the medical issues and the just completely stunted development of this 5-year-old is shocking to the conscience, to say the least. As the judge said at the end, he said, "I've done a lot of these, but this one I'll remember." And he's had over a 20-year career, and this is one that he said he's going to remember, and for good reason. Given those facts, the trial court easily could have given Depetro a maximum prison sentence of 8 years, and Depetro is in reality extremely lucky that was not the case. The trial court also probably took into account the fact that Depetro showed absolutely no remorse at any point for his actions. Even now, he incredibly tries to justify his crime by stating that he was, quote, working 2 different jobs and, quote, was not the child's natural father, as if the fact that the child was not biologically his somehow justifies his horrific abuse and neglect of this poor child. The record in this case, if you look at it, makes it abundantly clear why Depetro received the sentence that he did, and it was more than justified. If there are no questions, I would simply ask that this court affirm the judgment of the trial court. Thank you.
Thank you, counsel.
I do have a question.
Oh,
Mr. Bellucci, sorry if I messed up your clock, Judge Hensel. The trial court, obviously went through what it had to go through, and it made a, what seemed to me kind of a summarily found that the state would suffer prejudice, but it didn't really explain how in light of the timing here. And I mean, if it's because the child would have to testify, the child would have had to testify anyway, maybe, probably. So I'm wondering about really the omission of an explanation of what that prejudice would be.
Well, I think I don't think it's required to show that. That's one of many factors that you can take into account as the judge in your discretion. But I think at any time you have somebody that simply changes their mind and doesn't have a legitimate reason for changing their plea, that always prejudices the state. When if somebody's allowed to simply withdraw a plea for no good reason other than now you've decided to say that you're innocent and now you've changed your mind. So I think there's always prejudice there to the state in some respect.
Okay, thank you.
Sure.
Mr. Johnston, you have 5 minutes remaining for rebuttal.
Thank you. You're right. With respect to what trial counsel did at the motion to withdraw hearing, I would submit that he did nothing. He actually did damage because he didn't present any evidence. He could have presented the defendant at that case. We really don't know what the defendant would have testified to. And at that time, he could have testified to what his claim was in the written writing, that he was innocent, that there was an innocence. I mean, that's why the motion to withdraw was granted. And these cases are interlinked with the fact that people are going to be provided counsel who are going to do at least minimal that is required for motions of withdrawals, and that is putting on evidence, some type of evidence. And his defendant was there. With respect to the court's question about what kind of prejudice there could have been to the state on this case, there would have been no prejudice to the state on this case. if the motion withdrawal was granted. And while that is one of the considerations, it's a big consideration. There are some other considerations, but nothing would have been affected from the state. They could have tried the case, maybe convict this guy, and maybe he would have gotten more time. It's possible, who knows? But motions to withdraw should not just be granted to kind of keep the process of justice moving. Motions to withdraw, the reason why it's in there is the reason why there's a rule concerning it, the reason why this court has made rulings on it, is because it's a serious thing that requires representation, and it should have been granted. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Enjoy your day, gentlemen.